Each specialty field has its own requirements for possible testing, has its own protocols, has its own procedures. A key part of your contribution to the case is to understand your own field well enough so that you can decide what tests to run. You should be able to design each test as well as run or witness the tests. If experts in your field generally rely on third parties, such as independent laboratories, to run tests for you, you must be able to specify completely to the lab which tests to run and possibly how to run them. Since you will run tests as part of your investigation for expert witness testimony, you should conduct those tests under conditions as close as possible to the conditions that existed when the event or incident in question for your case originally took place. The legal burden that you have to meet is that you run your tests under conditions that are substantially the same as existed at the time of the event in question. If your tests are part of standard protocols or methodologies in your discipline, then the procedures that you follow should be similar to those described in peer-reviewed publications. In other words, if a professional journal in your discipline identifies relevant tests to run and guidelines for those tests, then you should run your tests according to those commonly accepted guidelines. If your tests require multiple passes to obtain a series of results or data values, you should run them enough times so that you can justify the results quantitatively. Ideally, you will be able to specify the tests needed to ensure a qualitative defense of your opinion as well. You may be asked why you ran specific tests, why you used or specified individual parameters, and even why other tests may not have been run. A key tactic to consider is that your eventual opinions will rely on the results you obtain from tests, and the results of your tests are only as valid as the tests you chose to run. You should be able to explain the logic and methodology that led you to decide exactly which tests to run and why the result or results led directly to your opinions. If your tests show any inconsistencies, you must also be able to explain those inconsistencies. They may occur as part of normal testing results, or perhaps as part of other unique conditions that may have existed on the day of your testing. Some tests have known error rates. If true in your industry, then you should obtain documentation in advance about these known error rates for your methodologies. You can then correlate observed error rates during your tests with the known industry error rates to help formulate a more effective opinion. If the case focuses on equipment that failed, perhaps, you will probably have to run tests that can explain the cause of the failure. You should define your tests to show whether the problems lay in original design or in follow-on manufacturing, or even usage by company personnel or consumers. Finally, if you or your testing service uses equipment to test other equipment, or equipment to test any evidence, you should know in advance whether the testing equipment has to undergo regular maintenance or calibration. If so, before running tests with that equipment, either your own or from third parties, you should verify that the equipment has had its regular maintenance or calibration performed. Obtain documentation of that service, along with the date of the service, along with any standards applied to the service and the organization that performed that service for you, or just for the equipment. Keep this information in your own file folder as well. If an opposing attorney can determine that you or your laboratory did not maintain or properly calibrate the testing equipment, then the judge might dismiss the results obtained from those tests. If the equipment does not require calibration, perhaps because results are relative and not absolute, you should know that so that you can testify to it later. In regards to taking notes, you will need to document everything you do to come to your opinions. This means that you should take notes regarding what dates you met with certain people, who they were, names, what you did while you were there, what you asked, and what you discovered from them. But don't write down or scribble additional notes on those same pieces of paper with your notes that include any premature judgments or opinions or observations about people and events. Just write down the facts. You'll use those facts to draw conclusions later. Don't write down any preliminary guesses or observations, since your notes, including any scribbles, are fair game later for an opposing attorney's questions. Key tactic to remember: only write down concrete facts that you observe or gather. No guesses, no advance opinions.